my lords. I want to turn now, if I may, to the exceptions which have already been applied and recognised, starting with the concluded contract exception, using that expression in inverted commas, begging the question, of course, as to what exactly its scope is. We submit that there is an established exception that, without prejudice material, can be relied on to prove the existence of a concluded contract, and that is enshrined in Unilever, my Lord's first example at page 2444D, not necessary to go to that, when the issue is whether the without prejudice negotiations have resulted in a concluded compromise agreement. And we accept, and we've accepted below, that the exception applies not merely as to whether there's an agreement, but what the terms of that agreement are. Clearly, there are a number of different, as my Lord Clark was putting to me at the start of today, one can have oral contracts, one can have contracts partly in writing, partly oral. There can be circumstances in which the written contract is supplemented by a collateral oral term. These are instances where it may be necessary to prove not just the existence of a contract, but in the event of a dispute, what the terms of the contract were. And our submission is that the exception goes no further than that, and it doesn't go so far as to allow, in the event that there is no dispute as to the existence of the contract or what its terms are, to allow either party to produce evidence as to what its terms meant. That is our submission, as your lordships appreciate. Now, every statement of the exception that one finds, possibly with one exception, we set out the references in paragraph 49 of our case, and I wasn't proposing to take your lordships to them, but in paragraph 49 of our case, which is on page 25 to 26, we set out the way in which the exception, the established exception, has been formulated, and we give various references there to Cross and Tapper, Phipson, Passmore, who is actually a bit more explicit in terms which obviously we support in the italicised or emboldened last sentence, references to Wever and references to McGrath. And so the way in which the exception has been formulated hitherto has, with one exception, not suggested that it is wide enough to cover factual matrix, construction, interpretation, or however one wants to phrase it. The one exception is referred to in our footnote 65, which I made passing reference to this morning. It is Sapinka on the law of evidence in Canada. That is at tab 66 in your lordship's bundle 3. It's referred to by my learned friends as a footnote in their case, so I'd better just take your lordships to it briefly. Tab 66. There is a supplement, but I believe I'm right in saying there's nothing in the supplement which updates this particular aspect. My lords, your lordships may note on page 813, as we're going to it, paragraph 14.216, Sapinka says, the editors say, it is accepted that the base of the privilege is a public policy to encourage settlement, then it follows that the privilege should extend to subsequent proceedings not related to the dispute which the parties attempted to settle. Any possibility of subsequent adverse use could deter full and frank discussion. The principle, once privileged, always privileged, applies. This is illustrated by Waxman. That Waxman is a tripartite case and was actually the case which was cited to the House of Lords in Rush and Tompkins. If your lordships then go on to page 816, paragraph 14.223, this is the one case one example, where matters are put more widely. The text reads this, if your lordships are there, 14.223, if the negotiations are successful and result in a consensual agreement, then the communications may be tendered in proof of the settlement where the existence or interpretation of the agreement is itself an issue. So I draw your lordship's attentions to that. The text, however, goes on to say such communications form the offer and acceptance of a binding contract and thus may be given in evidence to establish the existence of a settlement agreement. And then over the page, they say some courts have made the overly broad statement that once a concluded settlement is reached, the privilege is lost. This suggests that it's lost for the purpose of any subsequent suit, whether between the parties or strangers, no matter whether the agreement itself is put in issue in subsequent proceedings. However, this is paragraph 224, the better view is that the privilege applies not only to failed negotiations, but also to the content of successful negotiations, so long as the existence or interpretation of the agreement itself is not in issue in the subsequent proceedings and none of the exceptions are applicable. The rationale behind the privilege supports this position. If parties to settlement negotiations believe that their statements might be used by a third party in subsequent proceedings, whether or not they reached agreement, they might be less frank in those discussions. And clearly, as drafted, that text, and in particular its references to interpretation, are against my submissions. But I make 2 points about that. First of all, the body of the text, and in particular the second sentence of 14.223, directs the focus of the text to the rationale of the exception. Such communications form the offer and acceptance of a binding contract, and thus may be given in evidence to establish the existence of a settlement agreement. And secondly, none of the cases in the footnote, either footnote 482 or footnote 484, are in fact interpretation or construction cases. They are cases either, the first case, Perlman, which is actually in your lordship's bundles at tab 51, is a rectification case. The subsequent cases are existence cases where the documentation was being sought to prove the contract, to prove the existence of the contract. And there is nothing in those authorities that I have seen, none of these are being cited to your lordships, there is nothing in those authorities which, as it were, is a construction interpretation case, or indeed supports the use of the word interpretation in the text. Clearly the text as drafted with its reference to the word interpretation is against me, I acknowledge that, but the cases themselves are not cases in which a question of construction and the admissibility of evidence for construction has arisen.
Do they have the principle in Pren and Simmons that you can't look at previous negotiations to see what people thought they were agreeing in Canada?
I don't know the answer to that, Madam. I'm sorry, I would... But what one doesn't get from that, there's certainly nothing in these cases to suggest the sort of debate and the distinctions between Pren and Simmons admissibility and admissibility otherwise. They're all fairly short reports, and they're all dealing with disputes basically as to the existence of the contract and the offer and acceptance to enable the court to say whether there was a binding contract and so forth. I'm afraid I can't answer your lordship's direct question. My lord, just while your lordships have this bundle open, one other case was cited by my learned friends in their footnotes. It was at tab 53. The case of Rudd and Trossachs. This was a rectification case, and your lordships will see on the second page the authorities referred to were Cross and Tapper on Evidence, the 9th edition, London, Battleworth, 1999. And this was relied on in the Court of Appeal and is again footnoted in my learned friend's case at paragraph 14. And this is a rectification case, but in paragraph 14 on page 762, the judgment says in the second part of paragraph 14, if the settlement discussions are indeed successful and result in a consensus agreement, then the communications may be tendered in proof of a settlement where the existence or interpretation of the agreement is itself in issue. See, for example, Cross and Tapper on Evidence, 9th edition, 1999, at page 469. My Lords, we looked at this in the Court of Appeal. If necessary, I could give your Lordship a copy of this, but the formulation in Cross and Tapper on Evidence, 9th edition, Butterworth, 1999, at page 469, is in materially the same terms as the 11th edition, which is in your Lordship's bundle, and contains no reference to interpretation. So again, quite where that has come from is something of a mystery. Again, this was something which was put before the Court of Appeal. If your Lordships wanted a copy of the 9th edition at page 469, I could make sure your Lordships...
Well, one suspects that what the word interpretation here means is actually terms.
Yes.
Because what they're saying is you can prove the agreement.
Yeah. Well, the issue in this case was whether or not a settlement agreement which had excluded one defendant should be rectified to ensure that the missing defendant, who either had or hadn't been omitted by mistake, was included in a settlement which didn't identify him as a party to the settlement. I mean, clearly, if the word interpretation is construed in the way that my Lord has just suggested, meaning identifying the term, then clearly I have no problem with that in the light of my submissions. But it was referred to below, it's footnoted in my learned friend's case. I don't want it to be said that I haven't shown it to your Lordships, but subject to that, there is nothing in any of the formulations to suggest thus far that the exception goes to meaning as opposed to what the terms were. My Lords, the question arose during the course of my learned friend's submissions as to what the rationale of this exception was. And he made the submission to your Lordships, but with respect he did not back it up, that the rationale of this exception was that it was designed to promote settlement, to encourage parties to settle their disputes. And he made that submission as part of his first submission, which somehow involves the proposition that one doesn't get into the question of a privilege which you then have to show good reason to get out of. Rather, you say a concluded contract is somehow outside the privilege, it's designed to serve the same settlement interest, and therefore one doesn't need, as it were, to show good reason why there's an exception. None of the cases and none of the textbooks treat the concluded contract aspect as anything other than an exception to the scope of the without prejudice privilege. None of them support the proposition, I would respectfully submit, that the rationale of allowing evidence in to prove the existence of the contract or the terms of the contract is for the promotion of settlement.
So what is it?
What we say it is, my Lord, is twofold, perhaps. Firstly, it is a rationale born of necessity. It is impossible to prove the existence of the contract to which the parties have been negotiating in circumstances where the contract is not reduced to a signed written document, but is either made orally or, as in Tomlin's case, was contained in an exchange of letters, without adducing the evidence which shows the existence of the contract. And that rationale is actually, so far as one can glean, the rationale which appealed to the majority in Tomlin, which is at tab 43 in volume 3 of your Lordship's authorities. And there is an odd passage in the concurring judgment of Sir Gordon Wilmer, which my learned friend referred to. He didn't take your Lordship to this case. He was asked by your Lordships what the rationale was he asserted it. He said you didn't get much assistance from Tomlin. If your Lordship goes first to Lord Justice Dankworth's judgment...
Sorry, I thought we'd just gone to tab what?
Tab 43, my Lord.
Oh, I'm so sorry.
Sorry, my Lord, forgive me.
Tom.
Tab 43,
Yep.
And it is page 1382. And the issue in this case is whether one could effectively have a settlement which leftover liability but settled quantum or vice versa? In a sense, did you have to have an all or nothing settlement? The settlement as found was a 50-50 settlement of whatever quantum was subsequently determined. And the relevant passage which is highlighted is at 1382, letter G. A point which arises is that the letters written by the agent of the insurance company bore the words without prejudice. The point is taken that by reason of those words, there could not be any binding agreement between the parties. And it was said, indeed, on behalf of the defendants, that the letters were not admissible. So admissibility was in issue. I feel no doubt, as the judge felt no doubt, that the letters were admissible because the point was whether there had been a concluded agreement of any kind between the parties in accordance with that correspondence, and it would be impossible to decide whether there was a concluded agreement or not unless one looked at the correspondence. And so far as one can glean, that is the basis of his judgment. He then quotes from Lord Justice Linley at Walker and Wilshire, and then over the page at 1383b, we come to perhaps the second part of his analysis. That statement is a great authority, seems to me to apply exactly to the present case, if in fact there was a binding agreement, or an agreement intended to be binding, reached between the parties. And accordingly, it seems to me that not only was the court entitled to look at the letters, though they were described as without prejudice, but it is quite possible, and in fact the intention of the parties was, that there was a binding agreement contained in that correspondence. This disposes of the first point. So that was Lord Justice Dankford's. The concurring judgment at 1386 was Sir Gordon Wilmer. He concurs, not without doubt and hesitation, at the bottom of the previous page. And at the top of 1386a, he says it's not an issue that letters which are written without prejudice in furtherance of negotiations between the parties cannot be put in evidence unless those negotiations do in fact result in an agreement. It is, however, equally accepted, and this is the puzzling part of this, but it says it's equally accepted that the letters themselves can be, and indeed necessarily must be, looked at for the purpose of ascertaining whether any such agreement has in fact been arrived at.
Sorry, where was that passage?
1386a, my lord. Sir Gordon Wilmer concurring. And my learned friend made the point, your lordships, he said that really there was no issue on admissibility because of the words, it is, however, equally accepted that the letters can be and indeed necessarily must be looked at for the purpose of ascertaining whether any such agreement has in fact been arrived at. Quite clear that admissibility was an issue, apparently, from the earlier passage from Lord Justice Dankford's judgment at 1382g. So it's not the most fulsome, if I may respectfully say so, of analysis of an authority which has become cited as the bedrock of this particular exception. But in answer to my Lord Clerk's question, we say that what you get out of this is a recognition that it would be impossible to decide whether there was a concluded agreement, that it would be that it is necessary to look at it to see whether any such agreement has been arrived at. And you also have, latching on to Lord Justice Linley's language in Wilshire, which we've looked at before, Walker and Wilshire, the question of a new state of affairs being established and needing to look at this letter, or these letters in this case, to establish and indeed to prove the new state of affairs.
If you're putting that volume away, can we just pop back to tab 66?
Of course, Mark. Yes, sorry.
Page 815.
Yes.
Just to note with interest the passage that's inset. Also, it would seem that where the correspondence constitutes or leads up to a new contractual relation, which is in issue, in some or all cases, it ceases to be privileged. That rather seems to reflect the point I was putting to you earlier.
So
it's under page 815,
yes.
14.220, the actual citation from Waxman in the middle, in the
Yes.
second line.
I'm sorry, Molly, thank you, Molly. I'm afraid I hadn't picked that up. Waxman was the case cited to the House of Lords in Rush and Tompkins, And
It's Hutchison and Glover that might be interesting. Or Perlman.
well, Perlman is the rectification case which is
Yes.
in your lordship's
Yes.
bundle. I don't think Hutchison and Glover is
No,
in
it's
this
not.
bundle. We can obviously...
Anyway, this is a bit of a side
Well,
issue.
It's not in the light of the questions, of course, that your lordships
Yes.
have been putting to me. What the editors go on to say in 14.2.3 and 14.2.4 is that the privilege applies so long as the existence or interpretation of the agreement is not an issue. Now, that raises the question of what interpretation,
Yes.
which I
Yes,
touched your
yes,
lordship on
yes.
earlier. My Lord, just one other aspect, and I don't believe that this is in the bundle, but in Russian Tompkins, at the end of Lord Griffith's speech, I'm not going to take your lordships back to that, but there is a reference to an article by Mr. Brian Davenport in the Law Quarterly Review, which was very, very critical of the decision of the Court of Appeal in Russian Tompkins and its conclusion that the privilege lapsed on the concluding of a settlement. And that's not in the bundle either. The reference is given in Russian Tompkins. For your lordship's note, it is 1988, 104 Law Quarterly Review 349. And that has some... I don't want to take time up. I'm going back really to the point that my Lord Phillips has just made again. That has, again, an interesting analysis of the criticisms of the Court of Appeal decision in Russian Tompkins. And from memory, it talks about the need to prove the contract being something which is permissible, but very critical of the view that the privilege lapses generally, and it may be your lordships want to go to that, but it's not in the bundle. My lords, what the rationale is not in my submission is to promote settlement. Now, it may be the case...
I don't understand that. I mean, the only reason you need to allow the admissibility of letters exchanged without prejudice which have reached an agreement is because it would undermine the whole rationale of without prejudice negotiations if you didn't allow the outcome to be proved. And so it seems to me that the necessity and the rationale suggested are really the same, two different sides of the coin. The necessity follows from the desirability of promoting settlement.
There may be, my submission, just so your lordship doesn't, so make my position clear, my learned friend has two submissions, which in a sense he tries to keep separate. He says, allowing the evidence in, the factual matrix, promotes settlement.
Yeah.
And so you don't get into what he describes as a balancing exercise, although I would describe it as the privilege applies unless you come within an exception.
Yeah.
My lords, I accept, just so your lordship is quite clear about this, that it is entirely permissible for TMT to argue in this case, right or wrong, your lordships will decide, that without prejudice negotiations are privileged, and it may be in the interests of justice, it may reflect the intentions of the parties, that the exception for proving the contract is to be enlarged to cover factual matrix material. I accept that. Your lordships obviously have to decide that issue. What I don't accept is the submission which was made that somehow the avowed rationale was an analysis of the fact that this is consistent with the public policy of promoting settlement. It may be, as your lordship is putting to me, that when one analyses it, well, allowing factual matrix material in doesn't do much damage to the promotion of settlement. It may be in certain cases it does, it may be in certain cases it doesn't. The intentions of the parties are such that one should create an exception for it. But none of these cases suggest that somehow this stands outside the privilege and one doesn't get into the question of what the scope of the exception is. That's really my...
Yes, no, I wasn't really dealing with the matrix point. I was just saying that the actual admissibility of the contract seems to me difficult to regard as an exception to the without prejudice rule. It's really the other side of the coin. The whole point of the major point of without prejudice is to enable a contract. If you couldn't admit the contract, there wouldn't be any point in entering negotiations in the first place.
Well, it's the new state of affairs. You've actually given rise to
Yes.
a contract you're intending to be enforceable, and therefore, with respect, I'm simply putting it from a slightly different perspective, but we say that whether one characterises it as an exception or not doesn't matter, perhaps, for these purposes. You must be entitled to prove the contract, because otherwise the whole purpose of your negotiations which have been leading up to that are frustrated. Now, that does not go so far, we say, and in a sense I've already made my submissions on this, doesn't go so far as to say, well, proving the contract is one thing, proving a background fact said to be relevant to the interpretation of the contract is another thing. But I've made my submissions on that, and I would be repeating them. My Lords, the rectification point, which I need to deal with, is as follows. There are two decisions, one in Canada, that's Perlman, and one in New Zealand, Butler. Butler is tab 50. Perlman is, I think, tab 51. And Perlman is cited for your Lordship's note at Vaver, page 144, which support the existence of an exception for rectification. My learned friend, I think, made reference to Chartbrook, but Chartbrook isn't a without prejudice case. So there's no English authority, but there's Perlman, there's Butler, and Professor Vaver at 144. Now, one might say that the fact that there is a recognised exception for rectification of a concluded contract in an action between the parties to that contract supports the proposition that without some such exception, the privilege would apply in those circumstances. One doesn't need an exception for rectification to be recognised by Professor Vaver, for example, if after the concluding of a contract in a two-party situation in which interpretation is involved, all bets are off and anything goes in anyway. I'm not going to go to it. Your Lordships have the reference to Butler at tab 50. That was a construction case. There's not a lot of analysis, and so I'm not going to invite your Lordships to go there now. But when you read that, your Lordships will see there was an issue of construction as to whether the sale of chattels secured by a security instrument covered all chattels, as it implied, or only those which were on site. And it was suggested that the contract should be rectified to provide that it was limited to only those chattels which were on site. But the New Zealand High Court considered, but with not a great deal of analysis, so there's a limit to where one can take it, that the without prejudice rule applied, but that because it was a case of rectification, with the suggestion that the agreement, the written agreement, had an additional oral term which had been left out, the evidence was admissible. So there's a limit, because this sort of debate, which is occupying the Lordships for 2 days now, doesn't seem to have, as it were, featured high in the judgment. But certainly the premise of the rectification cases is that you need rectification in order to breach the rule.
You did describe Rudd, which we looked at it a moment ago, as a rectification case as well. That was whether Kaiser was a party to the
Exactly
contract
so,
or
yes.
not.
I'm sorry, thank you, Mark. Yes. So Rudd is another example, and in fact I didn't show you the appeal court as well, but it is a rectification case. My Lords, the argument obviously presents itself, it presented itself to Lord Justice Ward, well, if rectification allows the evidence to be brought in, why on earth does factual matrix evidence not come in on interpretation? And obviously I have to acknowledge that the evidence going in on rectification, that is an argument which clearly has some substance, and I have to deal with it. Rectification is, analytically, a different animal, and your Lordships will, I'm sure, appreciate that. The actual terms of the written contract have been produced in such a way that they do not reflect the prior consensus of the parties. It doesn't have to be in a previous contract, it's sufficient that there could be just an accord, a consensus between them, the effect of which is that the written contract and its terms do not reflect what has actually been agreed in the negotiations. Now, the law already recognises, as your lordships will appreciate, and it's specifically recognised by Lord Hoffman in Sharpbrook, that evidence of prior negotiations generally are allowed on rectification. Evidence of subsequent conduct is allowed on rectification. Indeed, evidence of subjective intent is allowed on rectification. And the references for your lordship's notes, paragraphs 42 and 64 to 65 in Sharpbrook. So clearly, if rectification is alleged, then as a matter of law, not to put too fine a point on it, the kitchen sink can be brought into the equation. Now, I appreciate that the lordships will say, well, if the privilege can go in a rectification case, why shouldn't it go in this case? And my response to that is that the fact that in an extreme case, a party may be able to plead rectification does not mean that in a case where he cannot do so, that the evidence of the prior negotiations, subsequent conduct, subjective intent, should be brought into play. Of course, in this context, we're not talking about subjective intent, we're not talking about subsequent conduct, we're only talking about a small subset of the prior negotiations, which, as it were, crossed the Sharpbrook line. But
there's a very learned article by Sir Richard Buxton in the latest number of the Law Quarterly Review, suggesting that since Sharpbrook, the line between rectification and some forms of matrix evidence is getting thinner and thinner.
My lord, it is certainly getting thinner and thinner, because what your lordship may have in mind is the fact that in Sharpbrook, the House of Lords didn't have to decide it on rectification, although, of course, Lord Hoffman said that if he'd needed to, the argument would have succeeded on rectification as well. But with respect, the line is getting finer and finer because, something has gone wrong sense with the language, and I appreciate the questions which were put to me by my Lord Sir John Dyson about earlier, but in the sense of the terms not reflecting the prior consensus, as apparent to the reasonable observer, Lord Hoffman's analysis of where rectification is available may be said to make rectification available in more cases than was previously thought to be the case. And indeed, Baroness Hale, at the end of her speech, your lordships may go to that in due course, she acknowledges that Lord Hoffman may have, as it were, widened the perceived ambit of rectification in certain of the observations that he made. With respect to my Lord Walker's point, I have to acknowledge that there are cases like the alligator example where the line between construction and rectification is a fine one. I have to acknowledge that. There's no getting away from that in the present context. But what your lordships have to consider in this case is whether the exception for rectification, which has been acknowledged and which will be available as a safety net, where factual matrix evidence is unavailable, but nonetheless rectification would be available, does that mean that in any case where it can't be said that we're into alligator on the banks of the Nile territory, where all that someone wants to do is adduce an evidence of a background fact, that the exception should be widened? I would respectfully submit that the rationale of the rectification exception is really exactly the same as the concluded contract, existence of the contract, new state of affairs exception, in the sense that the parties have negotiated, they've reached an agreement. If they've reached an agreement which is reduced into writing and signed and nothing has gone wrong, you produce the agreement, you prove the agreement, you need do nothing more. If it's an oral agreement, of course, you have to prove the oral agreement. part oral, part writing, you may have to do both. If you have a rectification case, the parties have made an agreement, they have intended that agreement to be enforceable in accordance with the terms that they have actually agreed, but something has gone wrong in reducing that to writing. The parties would obviously expect that what they had actually agreed would be available to the court to be enforced, reflecting the terms they had agreed rather than the terms that they hadn't agreed. Now, my lords, I can't shy away from the fact that construction and rectification, as my lord says, are getting narrower and narrower. But the danger simply by taking, with respect, the easy option of saying, well, we've now got to a stage where it doesn't matter, rectification and construction are getting close anyway, let's try and make this coherent by letting any evidence in relevant to what the parties meant on a construction basis as well. The danger with that is that whereas rectification is still only available and still only pleaded in very comparatively small cases, and one has to have a basis for doing so, and there's no case of rectification here.
It's very similar here, though, isn't it? I mean, their plea, in their estoppel plea, the common assumption plea, is very, very similar.
Well, I have to come to estoppel, but
it is very similar, though. The idea of a consensus is what you need for rectification. Well, a common assumption, which is what you need for estoppel by convention, is very, very close to it, isn't it?
My lord, I'm sure it won't have escaped your lordship's attention that the estoppel, which I will come to in a moment, which is pleaded, is not an estoppel that we are precluded from arguing our construction issue. When it's not said that we are stopped from arguing for a bilateral construction, it's not said somehow that Clause 5 was agreed. Something's gone wrong with the drafting of Clause 5, and clearly it's not said that the clause needs to be rectified. All that is said in this case by way of estoppel, and this is why it really is, in my submission, a very curious estoppel indeed, is that we are stopped from denying the background fact, which is the statement that the contracts were sleeved, that background fact said to be relevant to the construction of Clause 5. Now, I'm obviously leaping into the estoppel territory, but that is the estoppel, and it is a curious estoppel. It's actually, in the present context, I'm going to suggest to your lordship, a rather meaningless estoppel, because, and I'm moving away from rectification for a moment, but the primary case on factual matrix is that it is a relevant fact that we said that these transactions were sleeved. True or false, we said it informs the factual matrix. That's either admissible if your lordships are with TMT on this appeal, or inadmissible if your lordships are with us. For these purposes, it doesn't matter whether it's true, and for these purposes, in fact, it doesn't actually matter whether it was said, because if it was said in without prejudice negotiations, and my case is that what is said in without prejudice negotiations is inadmissible. The estoppel, I mean, for the purposes of the first argument on factual matrix, one is assuming in favour of my learned friend for the purpose of this argument that the statement was made and is relevant for the purposes of admissibility, purposes of construction. The estoppel argument simply says, well, you can't deny that the statement was made, therefore you can't deny the background fact. We say, well, any such background fact emerged only in the course of without prejudice negotiations and is therefore inadmissible.
They only rely on the estoppel just in case they can't get it in on as a part of the matrix.
Absolutely. It came as a response to our...
It's more difficult to prove an estoppel because you have to prove that it was intended to be relied upon and you did rely on it. Otherwise, it's precisely the same.
Well, my Lord, with respect, that's absolutely right, but it is important to note that it is an estoppel precluding my clients from denying the relevant background fact.
Yes.
The relevant my client's issue is a slight issue as to sleeved or non-sleeved and counterparty transactions or not. But my clients could admit the statement. It could be blindingly obvious. It could be contained in a written document, rather like Mrs. Offalu's, Miss Bossett's letter or email or whatever it was to Miss Offaly, there could be no basis for denying the fact that the statement was made. Therefore, there would be no question of any estoppel playing any part in the question of whether the statement was made. But the court would still have to grapple with whether a statement, if made, was admissible under factual matrix grounds. And that's why, my Lord, with respect to my Lord Clerk, and I've jumped ahead to the estoppel argument, it's actually not an argument which carries the debate further at all in the present context. For present purposes...
Well, it does in this respect, doesn't it? I mean, we're maybe jumping ahead in your argument, but if you can show not merely a background fact, but you can show a representation as the accuracy of the background fact intended to be relied upon by making the contract and relied upon by making the contract, then actually you move into a close analogical situation to that of misrepresentation and so on.
Perhaps can I come back to that on estoppel, because I'm in danger, obviously, of... in my submission, well, that's not in fact the correct characterization of this estoppel, but just confining it to rectification for present purposes. This is not a rectification case. I've already accepted, your lordships, as I must, the line in many cases between rectification and construction will be a fine one.
And why aren't you asking us to reverse the position on rectification? I mean, the view might be taken, this is a fortiori to rectification. I mean, are we bound by rectification? Is there any authority? We're not bound.
Your lordships are not bound.
I know, but why isn't it a I mean, logically, you must be saying it's absolute nonsense that you can try and get round a concluded written agreement following without prejudice negotiation, and somebody can then come along and say, well, look, if you actually go back into them without prejudice negotiations, you'll see that really we were agreeing something different.
Well, my Lord, we've obviously thought about what we should say on that very topic. I have to recognise that rectification is regarded as an exception by Professor Weber. There are Canadian, New Zealand cases, as I've referred to. And I also have to recognise that if it is permissible to rely on without prejudice negotiations to prove the terms of the contract, for example, an oral contract, it is difficult to see why, if the oral terms are written down wrongly in the written contract, how on earth the parties would not have intended their actual agreement to be enforced in accordance with their real terms. So, my Lord, with great respect, we've taken the view, and rightly or wrongly, rectification isn't an issue in this case, but I'm addressing your lordship on the premise that there is an exception for rectification. It may be much easier for me to say that there wasn't, but I am suggesting to your lordship that there is a line to be drawn between rectification and factual matrix in the question not just of analysis, because rectification still remains a different legal animal, but also in the context of the public policy rule and the implied agreement of the parties, which in a construction case is looking to admit the evidence not to prove what the real terms of the agreement were, but to prove a background fact said to be relevant to what admitted terms actually meant. And, my Lord, that's the line we draw. Your lordships may say, well, it's the wrong line, but I'm not sure I can add much more to that. My Lords, but your lordships are not bound by, in answer to that last question, my Lord, your lordships are not bound by anything on the question of rectification, and this is not a rectification case. Misrepresentation, my Lords, this is this is the third of my Lord Walker's examples in Unicover, which was, the second, an agreement apparently concluded between the parties during the negotiations should be set aside on the grounds of misrepresentation, fraud, or undue influence, and your lordship gave the example of Underwood and Cox. Now, Underwood and Cox, the facts of which your lordships can find at Wever, page 151, was the particularly nefarious case of a threat to expose the sister's private life unless she agreed to the brother's persistent demands that she give up certain rights under a will or under a settlement. And this was described by the court as nefarious. It's been described subsequently as egregious conduct. It undoubtedly falls into the case of the abuse of a privileged occasion, unambiguous impropriety. My Lords, there is an issue still to be decided. It doesn't arise on the facts of this case. I know my Lord Mance, made the point yesterday, and again just now, that we're close to misrepresentation territory, but we're not into a case where it is alleged that this agreement was procured by misrepresentation said to give rise to a right either to rescission or damages. There's never been any such claim to that effect. On the contrary, the defendants have sought to enforce the agreement in accordance with what they say its terms are. Were misrepresentation to arise, there is an issue as to whether the misrepresentation example of exception would cover an innocent misrepresentation, a negligent misrepresentation, or, of course, a fraudulent misrepresentation. There is a first instance decision in the commercial court, unreported, save that it is cited in Keane on the modern law of evidence at page 631, and also to be found, if one is interested, in the New Law Journal on the 30th of November 2007. And if your lordships wanted to see this, my learned friend has it, I could give this to your lordships, but there is an unreported extempore judgment of Mr. Justice Simon in the commercial court, where he held that negligent misrepresentations alleged to have given rise to a settlement agreement were not enough to breach the without prejudice rule. Now, my lords, that may be right or it may be wrong. The matter was appealed to the Court of Appeal but settled before it got there. But clearly there could be a debate as to the scope of the misrepresentation argument. Mr. Justice Simon's reasoning was that, by analogy with the abuse of privilege occasion cases, unambiguous propriety, it was not enough simply for it to be said that during the course of these meetings something may have negligently been said, which was subsequently said to be sufficient to give rise to an avoidance or rescission of a settlement agreement. And that was the issue that arose, and that was his conclusion. And so all I would say about that is that that is a still to be decided category of exception. I don't believe your lordships have to go into that territory, but it's right that your lordship should know that it is still an open one.
Which page was... it's 151 in Wever, Underwood.
Yes, sorry, my lord, yes.
Well, speaking myself, it would be perhaps helpful to have that, Mr. Justice Simons.
It's not the judgment itself, my lord, because it's extempore and there is no record of it whatsoever. What I can hand up to you, just to explain, and my own friends have this, is... Let's make sure it's all there. Yes, it is, yes. Thank you. Sorry? 1, 2, 3, 4. That's one more. That's it. Missing. My lords, what I'm handing up to you, lordship.
I mean, it's not going to encourage settlement negotiations very much if parties know that they're likely to be negligently misled without having any remedy.
No, I'm simply drawing this to your lordship's attention because certain points were made about misrepresentation yesterday, and I'm simply drawing to your lordship's attention the fact that there is an open issue as to the scope of that exception. Keane, the modern law of evidence, which I've given your lordship the extract from, there's reference to Offalu.
Do we know how modern?
Yes, it's 2010, my lord.
Oh.
Sorry, it doesn't say on the front, but it is 2010. My lords, 628, there's discussion about Offalu. 629 in the second paragraph there's a reference to what happens where a settlement is concluded. And then at the bottom of 630, there are a number of exceptions. One is the classic formulation, whether or not the negotiations resulted in an agreed settlement. But for present purposes, it's the bottom of this page, 630. The privilege cannot be, and then over the top of the next page, claimed when an agreement concluded between the parties during the negotiation should be set aside on the grounds of fraud or undue influence. And then it's the next sentence, negligent misrepresentations, however, will not prevent a claim to the privilege. And there's a footnoted reference to Jeffreys and Kavanagh. It's an unreported decision of the 19th of January 2007. It's extemporary, there's no written transcript, either online or available. And what I have then, and I apologise for the informal way in which this is handed up to your lordships, there is the best copy that I could find or take from the New Law Journal bound volume, and then behind that there is the internet version of the same article, which is clearer to read. And I'm not going to take time up with it, but it's there, and if misrepresentation rears its head, it's there for your lordships. I'm afraid that's not a very satisfactory way of citation.
Well, one always wonders whether the writers of these articles had something to do with the litigation.
I haven't even been able to find the answer to that question. But I make clear, I don't rely on it for the content of the article. I'm simply saying there is that reference in Keane which I found. The only reference to the decision which explains it is to be found in that article. I'm not relying on it for any other purpose. So, my lords, drawing the strands together on the first and the main point, factual matrix, my learned friend's first submission was that admitting this evidence serves the public interest in promoting settlement. And we say that that is a completely unrealistic view of the consequences which will follow, for reasons that I have already indicated. I'm not going to go back over them. We say it doesn't answer the implied contractual analysis of what the parties must be taken to have intended, and it is not the basis upon which hitherto the concluded contract exception has been recognised. We say next that my learned friend's third submission, doing it in a slightly different order, that the privilege seizes on the concluding of the settlement, at least in relation to a two-party dispute involving or relating to the settlement. We say that is wrong for reasons that I already explained. And we say that the real question for your lordships is, in fact, the second submission of my learned friend, which is it in the interests of justice, and is it necessary to give effect to the intentions of the parties who have been negotiating without prejudice to recognise a new exception to the without prejudice rule to the effect that either party is entitled to adduce evidence derived from the without prejudice negotiations which they consider to be relevant to the interpretation of the contract. And that is, analytically, we say, the correct question to answer. And we say, as your lordships know, that the answer to that question is no, because it will do more harm than good. In a very rare case, and as your lordships know, we say it is not this case, but we have to assume we may be wrong on that. In a very rare case, the effect of upholding the privilege will be a denial of more precise justice, because otherwise relevant and admissible evidence would be excluded. But that is a price worth paying to preserve the privilege and avoid the downside, the disruption, the disincentive to settlements that will otherwise follow. And to paraphrase Mr. or Professor Wever at page 94 of his article, we don't need to go to it, but the famous dictum that the truth should out and the truth should prevail has in this regard to be overshadowed by considerations that compromises settlement should be encouraged, and that if the price of that is that, as I say, a rarely different result obtains, that is what the parties would have taken to have agreed, rather than delving into the background and dissecting their communications. My Lords, estoppel and remoteness, in a sense, I've touched a little bit on the factual side of estoppel. Obviously, if I'm wrong on factual matrix, then one doesn't get to these points in reality. If we're right on factual matrix, we say that the contrived plea, and it really is a contrived plea, and I don't say that by way of criticism, but it is an attempt to try and finesse what on this hypothesis is a correct upholding of the privilege. The contrived plea of estoppel does not let in, as Lord Justice Longmore put it, by the back door what they can't get in through the front door. And again, I make the point that this is an estoppel directed to stopping us from denying the background fact, which is, my own friend picked up a reference in our case, but in fact, the background fact is the making of the statement, not whether the statement is true. And it is directed, therefore, to stopping us from denying that we made the statement. And as I already said in answer to my Lord Mance's question, were we to say, well, we did make that statement, but it was made in the course of without prejudice negotiations, and therefore it's inadmissible, there would be no room for the operation of an estoppel stopping us from denying that we made the statement, because there wouldn't be an issue about it, but it would still be inadmissible as a background fact, because it's still only exclusively derived from without prejudice negotiations. And so it's tempting again to say, well, there's an exclusion for estoppel and there's a pleading of estoppel, and therefore you're shafted on that basis. And we say that unless the law really has got to a state of affairs where any pleading of estoppel is sufficient to breach the privilege and take us to trial with the privileged material put before the court, then this gets the defendants nowhere.
It's a very odd plea of estoppel. Because something's true, you're stopped from denying it. Normally, the estoppel stops you from denying something that's false.
It is a curious estoppel. I don't want to take more time up on this point than one has to, because it is not the real point in this case, as your lordships will appreciate. But very, very briefly, in Hodgkinson, which is the Fons et Origo of the estoppel argument, and which has subsequently been approved in the Court of Appeal again in the House of Lords, Hodgkinson is at tab 22 of your lordship's bundle. That's volume 2 of the authorities. And the relevant context, as your lordships will have no doubt seen in Hodgkinson, is that the plaintiffs had desisted from bringing a breach of copyright claim as part of their initial proceedings alleging trademark infringement and passing off. And it was their case, although in fact Mr. Justice Neuberger rejected this on the facts, it was their case that they had desisted from pursuing their breach of copyright claim on the basis that they had held fire from doing so on the basis of what the defendants had said to them. That's what the facts in Hodgkinson were alleged to have been. One can see that in the head note if necessary, and in other parts of the judgment. But that's the context. And my lord, what had happened then was that the action had gone to trial solely on trademark infringement and passing off. The plaintiff had lost. The defendant had sought damages on the cross-undertaking of damages because there'd been injunctive relief. The plaintiff said, well, actually, you get no damages on your cross-undertaking damages because if we hadn't got the injunction for trademark infringement and patent, you would still not have been able to sell anything because it would have been a breach of copyright, therefore you suffered no loss. The defendant says, you are Henderson and Henderson, abuse of process, you should have taken that point early, you can't make it. And finally, we get to where the correspondence comes in, because the plaintiff then says, well, my answer to your Henderson and Henderson point is that the reason why I didn't make the copyright claim earlier is because you encouraged me not to do so. And that's the context in which it arose. And in fact, Mr. Justice Neuberger held that it wasn't made out in the facts, but it was in the context of effectively a representation that one didn't need to bring the claim forward, which was relied upon by not bringing the claim forward, allegedly, that the argument arose. And in the course of that, Mr. Justice Neuberger deals with estoppel at page 190. The first point that had been made was that in the light of Muller, it was admissions only, protected by the privilege, and Mr. Justice Neuberger rejects that because he made the point that there was an implied contractual basis for the privilege as well, and just two-thirds down the page, there's the statement, in fact, which I've quoted in my case, and which Mr. Justice Lloyd referred to in the David Instance case, which I showed your lordships. The parties are agreeing that the contents of the correspondence will not be referred to in the proceedings in which they're engaged or in which they contemplate. But the estoppel argument was the second argument, and as was observed to my learned friend yesterday, there are really two aspects to the estoppel reasoning. One is unconscionability, abuse of a privileged occasion, unambiguous impropriety. And the other is that there is an analogy with Tomlin. And the one thing that is stated unambiguously by Mr. Justice Neuberger at 191, halfway down the page, is that he does not suggest that there is any absolute rule. Says that in terms. I don't suggest there's an absolute rule to that effect. So, my lords, on the facts, on the assumed facts, which actually were rejected by Mr. Justice Neuberger at first instance, although from recollection, this isn't the bundle, he was reversed on the facts in the Court of Appeal, but that doesn't add anything to this analysis. But on the assumed facts, which he was considering in Hodgkinson, one had a case of a clear representation being alleged, which was relied upon, conduct taken or not taken, and it would have been undoubtedly unconscionable for the Henderson and Henderson point to have been maintained. And in a sense, you're into not a contractual state of affairs, but a sort of quasi-contractual desisting from doing something in the light of something that had been represented, which is quite outside, if one likes, the scope of the negotiations and any contract in relation to the disputes that arise out of it. Now, one can well see, for example, that if Mrs. Offalu had been able in the Offalu case to say, in the light of your letter, which was an implicit acknowledgement of title, in the light of that letter, I desisted from commencing any proceedings because there was a representation in it. And therefore, it would be unconscionable for me to be time-barred as a result of what happened. One could see where an estoppel might arise. Indeed, that point was made in paragraphs 99 to 100 by Lord Neuberger in that very case. But if Mrs. Offalu had said, well, I saw your letter and your implied acknowledgement of my title, and it may not have been common ground on the pleadings, but I assumed from that at the time that you were admitting my title, and I conducted my negotiations on that basis. They were abortive, of course, in that case. You can't turn around and say you didn't make the statement. For that reason alone, they wouldn't have avoided the limitation problem that arose in Offalu simply by saying, well, you're stopped from making the statement which I'm trying to rely on for the purposes of limitation. It's either good for those purposes or it's bad. And my submission on the stopper, and I really don't want to labour this any further, is that it is, with respect, a tail-end Charlie point, which was dreamt up as an answer to the factual matrix strikeouts. And if we're right on factual matrix, then you don't get round that by seeking an estoppel to allege the very factual matrix fact, which is inadmissible for the first reasons that we gave. My Lords, that leaves remoteness, finally. And again, I venture to suggest that if we're right at the first stage of our argument, it is very hard to see how on earth we should be wrong at this stage of the argument. The premise has to be that although it's not in the interest of justice, it doesn't reflect the intentions of the parties, that without prejudice material should be allowed in on construction. Nonetheless, it is in the interest of justice, and it does reflect the intentions of the parties, that on the secondary question of breach, parties should be allowed to bring in without prejudice material. And that, with respect, is an unsustainable proposition. The factual premise of this gets extremely hard in any event, because at this stage of the argument, it's a bilateral obligation. We've got over causation. There may be mitigation arguments which arose, my Lord Mance made one, but our loss has been sustained as a matter of causation as a result of a breach. On the face of it, one would have thought that the loss flowing naturally from the failure to close out is the difference between the financial position we're in and the financial position we would have been in. Even if one brings into play the Achilles and the question of assumption of responsibility, that's actually not going to alter very much. So factually, this seems to be an attempt to resurrect by way of damages the same point that this is actually a trilateral rather than a bilateral arrangement, which on this hypothesis they have already lost. And so it's not a promising start, but even looking at it as a matter of principle, the idea that statements as to one's financial affairs, one's contracts, one's plans, present, past, or what's happened in the future, or what will happen in the future, the idea that statements would be admissible for these reasons will again run counter to the policy rationale of encouraging people to speak freely about their financial affairs, not dissecting conversations, all the same ground which I've already covered first time round, and which I don't believe it would be productive to explore again. If anything, we would say that this is the very situation where really to allow matters to be explored to enable a contract breaker to exonerate itself by reference to things that were said during the course of negotiations could well put a premium on breach, could well encourage people to, as it were, seek to extract materials from another's unguarded comments. So, my Lords, in reality, as I suspect everyone recognises and has recognised all the way up, this is about factual matrix. And it comes back to the very clear questions that have been identified throughout both my learned friend and I hope my submissions. And we say that your Lordship should draw a line and whatever has gone before as regards other exceptions, we're not into that territory, and one should not open up the privilege to allow evidence of factual matrix. My Lords, I'm sorry, I have gone on, but unless there...
Does it follow from that that you're essentially conceding that if you're wrong on factual matrix, you're also wrong on remoteness? Because I didn't really understand remoteness as being a kind of advanced as a fallback, but maybe as a different weapon based on the same principle that might be needed on the facts.
If I am wrong on factual matrix, then the evidence on these representations is going into trial, and I'm not going to be saying to your Lordships it would be impossible for a trial to be conducted on this basis, and indeed the greater must include the lesser in a sense. So if this evidence is admissible on construction, it's hard to see how it cannot be admissible on a question which, if it's not a question of construction, is raises some issues of what the parties contemplated the damages would be. So the answer to your Lordship's question is, if I'm wrong on factual matrix, I'm not saying to your Lordships that evidence should be excluded for the subsidiary arguments. What I am saying to your Lordships is, if I am right on factual matrix, they can't be in a better position on remoteness, which is a subsidiary aspect, at best, of the contemplation of the parties. Damages issues are secondary, although they may be very important, but nonetheless, parties who ex hypothesi have not envisaged that materials relevant to construction should go in would equally, or a fortiori, not envisage that they would go in on damages. So that's my position, my Lord. My Lords, unless I can assist your Lordships further, those are our submissions.
No, thank you very much. Mr. Willam? Yes, Mr. Crewe.
My Lords, I was going to be very brief in reply, just taking a few points in the order in which they arose. Yesterday afternoon, my learned friend spent a certain amount of time on the facts, which I wasn't proposing to dwell on. The thrust of his point seemed to be that this case didn't turn on very much, but our response to that is, if there was a point of substance there, it was a point that should have been taken on the question of leave to appeal, not as an opening swipe in the submissions once the permission has been granted. And secondly, it isn't a point. If this issue in this case alone meant nothing, one wonders why it was in fact Oceanbulk that launched the application to strike out these paragraphs, and why, when they failed, they appealed to the Court of Appeal. We are here entirely because it is clearly, certainly their view, that these paragraphs are going to matter at trial, and that was certainly the judge's view at first instance. So in our submission there is really nothing in, as I say, that sort of preliminary swipe. The second issue my learned friend addressed was the supposed difference, it appeared, between the public policy-based privilege and what he called the contractual-based privilege. But in answer to a direct question from my Lord Clerk yesterday afternoon, and again, the very first thing he said opening this morning, he acknowledges that the scope of the two is exactly the same, and they are subject to exactly the same exceptions. And therefore, the question before you is simply, what is the true scope of what he calls the exceptions, what we call the boundaries of the privilege itself? Nothing turns on characterising this as either contractual or public policy based on his analysis, and we submit that is entirely correct. If it is of any interest, the fact that it's correct was actually commented on in the David Instance case that he took you to at page 884, that the contractual basis is going to be subject to exactly the same exceptions or parameters as the public policy basis. So nothing turns on that, and we apprehend, therefore, that my learned friend has sub silentio actually abandoned one of the arguments that is advanced in his case. Just for your note, I don't ask you to turn it up, but at paragraph 56, 7 and 8, he says, if contrary to what is said above, the public policy rationale for without prejudice privilege does not justify the exclusion of this evidence, then it should be excluded on the contractual basis. That's what he says in his printed case at paragraph 56. It is apparent from his oral submissions that that line of argument has been abandoned, and it is not now being suggested that there is any contractual reason for excluding this material if it can't survive the public policy scrutiny. Our submission that is entirely right, and we have nothing further to say. The Weber article, as we point out in our printed case, contains a slightly more extensive critique of the whole concept of the contractual basis, but I don't need to get into that because nothing turns on it in this appeal. Working through a number of other points that arose today, as I say, just in the order in which they arose, my learned friend suggested that the public policy which applies to the privilege means that factual matrix evidence, if it were admitted, would constrain negotiations because parties would be nervous about things they say being used against them. Now, in our submission, that in a sense, that's the core of his answer to our main point, and with the greatest respect, there is simply nothing in it. Because factual matrix evidence is simply in a different category from admissions. Admissions are, by definition, admissions against interest. Factual matrix evidence is simply the material that is common to the parties, blind as to who it comes from and blind as to who it assists. So to suggest that lawyers are going to be sitting by their clients' elbows in the course of without prejudice negotiations saying, oh, you'd better not say that, because if you say that, the court might understand what the contract really means, is not a particularly realistic concern to wave in the court's face to encourage the exclusion of this evidence. The other thing we just wanted to say about this is that it is always tempting to be blinded by the facts of the case in front of you. On the facts of this case, the material we are seeking to adduce happens to have come from Oceanbulk, so it sort of looks a bit more like an admission. But in another case, it could be the other way round. It could be TMT seeking to introduce into the trial material which it put into the without prejudice negotiations. If my learned friend's submission is right as a matter of principle on the law, we would be precluded from introducing that. Not because it's an admission against interest by him, because it's actually evidence that would come from us, but he would be still saying, well, you can't introduce it because it came out in without prejudice negotiations. And in our submission, if you turn hypothetical facts around like that, the principal objection to the introduction of the evidence disappears. And that is also, we would suggest, an answer to the phrase that was conjured from the John Tracy article about unjust enrichment. We're not seeking to gain an advantage from something that was conceded in the course of without prejudice negotiations. As I say, the argument we are advancing would render admissible evidence irrespective of its source.
In some contexts, it might be an admission, mightn't it? I mean, you can't say there's an ineluctable rule that factual matrix evidence is not an admission. It might be an admission, as I suggested yesterday, that we own that or we control that company. That might be a very material fact in the litigation.
Well, if there is something that is both admission and factual matrix, then the answer, the sort of three-part answer I gave to my Lord Simon Brown yesterday, but it is our response to that. The next point we just wanted to touch on, there were moments in my learned friend's oral submissions where he appeared to be holding something that looked like floodgates arguments up in the air. We would submit that there's really nothing in that. You can't test a point of principle by reference to what would happen if the legal rule were abused or misused in practice. And as my Lord Clerk said, some of what he was saying, if it was well-founded, would be an objection to the introduction of factual matrix evidence per se, and that is an argument that has been lost long since. Next point, my learned friend spent a certain amount of time in the case of Foulouet and Bossert. I don't propose to go back to it in any detail. The points that we just wished to remind your lordships about in that case were, first of all, that it was a case in which there was no settlement agreement, so it is quite simply an entirely different category of case from the present one. It was an implied admission case. It was an attempt to throw back and take advantage of something that somebody had said. That's expressly put in paragraph 97. And finally, the third point we want to make is that it was expressly recognised in Foulouet and Bossert, paragraph 91, that exceptions such as those in the eight-part list in Unilever may allow evidence in. Paragraph 91 says in terms, quite apart from this, it appears to me, this is in the speech of Lord Newburgh, the leading speech, save perhaps where it is wholly unconnected with issues between the parties to the proceedings, a statement in without prejudice negotiations should not be admissible in evidence other than in exceptional circumstances such as those mentioned in Unilever. And that is another illustration of how the categories of situation in which without prejudice material may be admitted is plainly not closed, and the list in Unilever is not an exhaustive list. The next point we just wanted to deal with was the suggestion that this is the first case where this point has ever arisen, and therefore somehow it can't really matter in the grand scheme of things. With respect, first of all, factually, we would submit that is simply not correct. We do submit, although it is a footnote point, and I don't propose to deal with it in any great detail, but we do say that the Admiral Management case is properly analysed by Lord Justice Ward. Admiral Management was a case in which extraneous evidence was admitted in order to interpret a settlement agreement, to suggest that the material that was looked at was actually impliedly referred to in the settlement agreement itself is stretching the point. But in any event, it is, in our submission, an illustration of an earlier case. But in any event, the question of whether or not there are any reported cases on this point doesn't really take the argument one way or the other. What may be happening up and down the country in the courts the whole time is that the courts may be admitting this kind of evidence without dispute, because that is within the reasonable contemplation of parties. We simply do not know what the position is. And it is, in our submission, quite unrealistic to suggest that it is going to be a rare case in which evidence might be sought to be adduced in order to aid the interpretation of a contract entered into following without prejudice negotiations. One can imagine any number. I should think certainly the lower courts are filled with cases, for instance, of boundary disputes. One can quite imagine having a boundary dispute settled at the door of the court under the pressure of the judge just about to come in, agreeing to draw a line from the cherry tree to the oak tree. Turns out there isn't a cherry tree, but they've signed an agreement referring to a cherry tree. The court then has to work out, well, which tree were they talking about? That kind of thing at a more mundane level is bound to happen in numerous occasions. And so to suggest that somehow you needn't worry about this or that this is a completely exceptional case and that an exceptional rule shouldn't be developed is, with greatest respect, an unrealistic proposition. The next point I just wanted to address, my learned friend took you to Rush and Tompkins. Rush and Tompkins says what it says in the context in which it said it, and I don't propose to go back to our submissions about that, distinguishing the particular circumstances of that case. But what I did want to urge on you is simply this, that we are not trying to urge on you necessarily a bland proposition that simply because there has been a settlement agreement, therefore all without prejudice material becomes admissible. The proposition we made, which I hope I made clear yesterday, is a much more modest claim, which is that as between the parties to a settlement agreement, without prejudice material is admissible in relation to disputes between them about that settlement agreement. Your Lordships may wish to go further, but we don't need to urge you to go further than to say that that is an appropriate result in this case. The next point I just wanted to mention is simply this. My learned friend spent a certain amount of time taking you to the David Instance case. That was, you will recall, a first instance decision of Mr. Justice Lloyd, as he then was, in which certain material was considered not to be admissible. I'm not going to take you to it, but in the courts below, the other side played David Instance. We played another first instance decision which went the other way, a case called Sport International Bussum, which was a decision of Mr. Justice Peter Gibson, Bundle 3, tab 41. All it illustrates is that the lower courts have found it difficult to come to a consistent view. Yes, Mr. Justice Lloyd said what he said in David Instance, but Mr. Justice Peter Gibson said what he said in Sport International. So at first instance, the parties are quits. It doesn't really advance the thinking that you will be having to do to go into those authorities in any great detail. Finally, the real heart of the argument turns on what my learned friend was trying to say in relation to what he calls the exceptions, what we would call the proper boundaries, parameters of the rule. And it is at this point in our submission that his argument unravels. In relation to concluded contract, he has to accept that once there is a concluded contract, the without prejudice material which actually contains that contract is admissible. And in answer to a question from my Lord as to why that is so, if it's not for the reason that we suggest, he said, well, it's born of necessity. Well, that, with the greatest respect, doesn't answer the question at all. Why is it necessary to allow parties to prove this contract? For the very obvious reason that if you don't allow parties to prove the contract which they've entered into following without prejudice negotiations, there's no point in entering into without prejudice negotiations. So allowing people to prove the contract advances the public policy on which the privilege is based, which is to encourage negotiations and out-of-court settlements. It really couldn't be clearer than that. And I have to say, my Lords, with respect, we remain completely at a loss to understand why, as a matter of policy, the court should wish to find the law in the position of saying that you can adduce with evidence of what the contract is, but not adduce evidence of what it means. There is just no sensible policy reason for reaching that conclusion. In relation to rectification, the position is even worse for my learned friend's argument. He attempts to draw an analytical distinction between a rectification where he says something has gone wrong with the language and interpretation. But with respect, one only has to look at what was said in the sorry, my note has gone blank at this point. The Chartbrook case. Chartbrook, sorry. Chartbrook, which is Bundle 1, Tab 9, which he took you to this morning. I would just draw your attention to paragraph 14, which I suspect may be the text. I'm sorry we weren't up to speed with Lord Justice Buxton's article in the Law Quarterly Review, but this paragraph 14 may well serve as the text of that article, I don't know, because Lord Hoffman here revisits very briefly the authorities that we have cited to you already. And he says this: there is no dispute that the principles on which a contract or any other instrument or utterance should be interpreted are those summarised in ICS and West Brom. They're well known and need not be repeated. It is agreed that the question is what a reasonable person, having all the background knowledge which would have been available to the parties, would have understood them to be using the language in the contract to mean. The House emphasised that we do not easily accept that people have made linguistic mistakes, particularly in formal documents. Similar statements are found in BCCI and ALI and so on, but said that in some cases the context and background drove a court to the conclusion that something must have gone wrong with the language. In such a case, the law did not require a court to attribute to the parties an intention which a reasonable person would not have understood them to have had. So what his lordship is clearly saying there is that context and background, in the context of an interpretation exercise, not rectification, that context and background can lead the court to the conclusion that something must have gone wrong with the language. That's exactly what was being done in the case of Manai, where 12th of January was read to mean 13th of January, because something had gone wrong with the language. And so, with respect, one can entirely sympathise with the views expressed apparently by Lord Justice Buxton, that the line between rectification and interpretation is extraordinarily thin, if not invisible, because the court is prepared to look at contextual material in order to understand whether the words on the page were intended to mean what they apparently say. And so to suggest that there is a conceptual difference between rectification, where something has gone wrong with the language, and interpretation is, with respect, an untenable argument in face of what is said in the Chartbrook case. Lords, we don't, I think, need to say anything in response to the Keane and the first instance decision of Mr. Justice Simon. And there's nothing, I think, that we need to add to what we have already said in relation to estoppel or remoteness that we haven't said already. The point you have well on board is the very, very short one, that if this appeal is dismissed, what you will be telling litigants and potential litigants in the future is that the courts are less well equipped to understand the intended meaning of a contract which is made on the basis of without prejudice negotiations than they are to understand what any other kind of contract means. And for those reasons, we would invite your lordships to allow the appeal.
Can I just ask one point? You mentioned conflicting first instance decisions, David Instance and Sport International. That was on what point?
That was simply on the question of whether or not the making of a settlement agreement, a bipartite settlement agreement, allowed those parties then subsequently to shut out subsequent reference to the without prejudice material that led up to them.
Yes. The point that I looked at Sport International, and the point that I noticed is that, it deals with the rectification point. It's a further case which supports that possibility. But interestingly enough, this is a consent settlement order. It also deals quite extensively with the question whether you can refer to the factual matrix in order to construe a settlement agreement.
Yes.
And it assumes you can.
Yes, indeed. Indeed it does, yes.
Yeah.
As I say...
He says the principles in Plen and Simmons apply, but there's a difficult line between factual matrix and what is excluded.
Absolutely. The relevant passage is sidelined. But Lord, that's entirely right. I didn't want to belittle it. It's simply that in the interest of economy, in front of your lordships, we didn't want to dwell too much on first instance decisions, since you're addressing a question of principle on which no doubt you will form your own view.
We were asked whether there had been any previous cases.
I'm sorry. Yes,
and I suppose it's relevant on that.
You're quite right. I'm sorry. Lord, unless there are any other questions, those are our submissions in reply.
Yeah. Thank you very much. The court is grateful to counsel for their submissions and will take time to consider its judgment.